The sound of a heavy oak door locking from the inside of a federal courtroom is a sound that very few people ever hear. It is a sound that signifies the absolute terrifying end of polite conversation and the beginning of raw, state-enforced power. And at exactly 11:47 a.m. this morning in Manhattan, three of the most expensive defense attorneys in the United States heard that sound. And for the first time in a long time, the color drained out of their faces. If you are watching this, you need to understand that we are no longer in the realm of legal maneuvering. We have crossed the Rubicon into a full-blown constitutional stress test. What happened today wasn't a legal strategy. It was a crime scene of arrogance. Here is the cold, hard reality of what went down. We were in the middle of what was supposed to be a routine procedural argument. The air conditioning was humming, the court reporter was typing, and the prosecution was laying out financial documents. Standard white-collar boredom, right, wrong. Suddenly, lead attorney Robert Sterling and his team, people who charge more per hour than most Americans make in a month, stood up. They didn't ask for a recess. They didn't ask for a sidebar. They gathered their papers, turned their backs on a sitting federal judge, and attempted to physically flee the proceedings. Let me be crystal clear about how insane this is. In the ecosystem of American justice, you do not simply walk out on a federal judge. You can walk out on a bad date. You can walk out on a boring movie, but you do not walk out on Article 3 of the Constitution. But they tried, and this is where the movie scene happens. This is the moment that will be studied in law schools for the next 50 years as the textbook definition of hubris meets reality. The judge presiding over this chaos is Judge Patricia Caldwell. Now, the spin doctors are already on Twitter screaming about liberal activist judges. Save your breath. Caldwell is a Reagan appointee. She has been on the bench for 31 years. She is old school conservative jurisprudence incarnate. She runs her courtroom with the precision of a Swiss watch and the temperament of a heavy artillery commander. When she saw these three attorneys trying to abandon their client and make a break for the exit, she didn't bang her gavel. She didn't raise her voice. She simply leaned into the microphone and delivered the single most gangster line I have ever heard in a federal record. Counselors, if you take one more step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest. Freeze frame. Imagine the scene. You have three high-powered lawyers freezing mid-step like teenagers caught sneaking out of the house. But Judge Caldwell wasn't finished. She didn't just threaten them with words. She escalated the force posture. She ordered the United States Marshals to seal the room. Within seconds, 6 armed federal agents moved to block every exit. The doors were secured. The exits were cut off. For 7 minutes and 23 seconds, the legal team representing the former president of the United States was effectively held hostage by their own stupidity. This was a standoff, a literal, physical standoff between the performative outrage of political operatives and the coercive power of the federal government. And guess who blinked? The lawyers sat back down. Of course they did, because despite all the bluster, despite all the cable news appearances, nobody wants to spend the weekend in a holding cell in Lower Manhattan. But here's the question that should be keeping you up tonight. Why? Why would a legal team comprised of seasoned veterans who know the rules of the game better than anyone attempt a stunt that they knew would result in sanctions? Why would they risk their law licenses, their reputations, and their personal freedom just to stage a walkout that lasted less than 8 minutes? You don't pull a fire alarm unless you see smoke, and you don't try to flee a courtroom unless you are terrified of what is about to be said on the record. This wasn't a tantrum. This was panic. Pure, unadulterated panic. These lawyers weren't running away from a ruling. They were running away from a revelation. They knew something was coming down the pipe that they could not defend against, and their only remaining card was to blow up the trial before the truth could come out. So, what spooked them? What happened 48 hours ago that turned a confident defense team into a group of fugitives trying to escape their own trial? To understand that, we have to look at a clerical error that lasted exactly 17 minutes, a mistake that revealed a secret so damaging, it forced the defense to hit the eject button. You know, the old saying in Washington, it's not the crime that gets you, it's the cover-up. Well, in this case, it's not the crime or the cover-up, it's the refresh button. For exactly 17 minutes on Wednesday afternoon, the federal court's electronic record system, PACER, had a glitch, a clerical error, a digital slip of the tongue. For 17 minutes, A sealed filing was visible to the public, and in the year 2024, 17 minutes is an eternity. It's enough time for legal researchers, journalists, and half of Reddit to download the PDF, screenshot every page, and circulate it to the ends of the earth. So, what was in the box? Why did this specific document make a team of million-dollar lawyers try to physically claw their way out of a courtroom? According to sources who snagged the file before it was scrubbed, we are looking at the holy grail of white-collar prosecution, the financial paper trail that wasn't supposed to exist. The defense has spent months building a narrative around a blackout period. They claimed there was zero contact, zero money moving, zero coordination between the former president and his co-defendants during the critical window. That was their shield. That was their entire defense theory. This document didn't just crack that shield, it vaporized it. The filing allegedly details $4.7 million in wire transfers. Not cash in a bag, not handshake deals, wire transfers. Traceable, time-stamped, immutable banking records. And worse, these transfers correspond almost to the second with encrypted communications that the defense swore never happened. When Judge Caldwell ruled those 847 pages admissible this morning, the defense team realized they were walking into a buzzsaw. They weren't just looking at a losing argument, they were looking at perjury traps. They realized that every word they had said in their opening statements was about to be contradicted by the defendant's own bank account. But wait, it gets worse. If the money is the gun, then Judge Caldwell's announcement about the ex parte submission is the bullet. For those of you who didn't go to law school, let me translate ex parte for you. It means one-sided. It means the prosecution got to show the judge something so sensitive, so dangerous, or so classified that the defense team isn't even allowed to see it yet. Federal judges hate ex parte communications. They are allergic to them. It goes against the grain of open justice. So when a judge like Caldwell, remember 31 years on the bench, rigorous conservative, says she accepted an ex parte filing from the DOJ, alarm bells should be ringing in every law firm in Manhattan. And then she dropped the hammer. Based on this secret filing, she is considering sequestering the jury and enhancing security. Every criminal defense attorney knows exactly what that code means. It means the prosecution has flipped someone on the inside, someone who requires physical protection because what they know is radioactive. The court filings refer to this person as Witness 14. Let's do a little deductive reasoning, shall we? Who qualifies as Witness 14? They have been in protective custody since October. They have direct knowledge of the financial plumbing of the organization. And their testimony is scheduled for next Tuesday, exactly 96 hours after the lawyers tried to stage their walkout. This isn't a low-level coffee boy. You don't put a secretary in protective custody for months. This is a CFO. This is a controller. This is someone who knows where the bodies are buried because they helped dig the holes. This explains the panic. The defense team looked at the calendar, they looked at the admissible evidence, they looked at the empty chair where Witness 14 is going to sit on Tuesday, and they did the math. They realized that once Witness 14 opens their mouth, the narrative control is gone forever. The witch hunt slogan doesn't work when your own accountant is reading the receipts into the microphone. So, panic makes sense. Fear makes sense. But what happened next? That wasn't panic. That was choreography. You see, when people truly panic, they are messy. They are unpredictable. But when Robert Sterling's team tried to walk out, it didn't feel like a spontaneous combustion. It felt like a scene from a play. And if you look closely at the timing, at the text messages, and at the cameras waiting outside, you start to realize that this breakdown of the legal system might have been the most organized part of the entire trial. Because while the lawyers were playing the victim inside the courtroom, a very different machine was spinning up outside on the street. In politics, there are no coincidences. There's only planning and bad planning. And what happened in Judge Caldwell's courtroom has the fingerprints of a very specific kind of planning all over it. Let's look at the timeline again. But this time, I want you to look at what was happening outside the doors. At 11:47 a.m., the lawyers stand up to walk out. But 45 minutes before that, at roughly 11 a.m., production crews from Fox News were reportedly spotting up outside the courthouse. Not the usual gaggle of freelancers, but full crews positioned for a breaking news stand-up. How did they know? Did they have a crystal ball? Did they read the tea leaves? Or did someone send a save-the-date card for a constitutional crisis? And then there is the text message. This is the detail that turns this from a legal drama into a dark comedy. According to leaks from within the defense support staff, at 11:42 a.m., exactly 5 minutes before the walkout attempt, lead attorney Robert Sterling checked his phone. He allegedly received a message consisting of 2 words: Abort Mission. Abort Mission, who talks like that? Campaign managers talk like that. Fixers talk like that. People running a PSYOP talk like that. The source claims this text came from a senior political strategist, not a legal consultant. Think about the implications. If this is true, it means the lawyer standing before a federal judge wasn't taking orders from the Constitution or even from his client. He was taking stage direction from a spin room. The walkout wasn't designed to win a legal argument. It was designed to create a thumbnail. It was designed to create a 15-second clip for the evening news and a donation link for the email blast that went out 20 minutes later. And sure enough, look at the reaction. Before the Marshals had even finished securing the doors, the true social machine was already firing on all cylinders. Rigged trial, judge threatening arrest, election interference. The graphics were ready, the copy was written. The outrage was prepackaged, vacuum sealed, and ready for consumption. This is what we call the outrage industrial complex. The goal wasn't to protect the client's rights. The goal was to delegitimize the court. By forcing a confrontation, they wanted Judge Caldwell to look unhinged. They wanted the visual of Trump's lawyers being threatened with arrest. They wanted to provoke a reaction that they could sell to their base as proof of tyranny. They were trying to goad a federal judge into making a mistake. They were poking the bear, hoping the bear would bite them so they could show off the scars on cable news. But here is where the strategy backfired. Judge Caldwell didn't bite. She didn't lose her cool. She just locked the doors. She treated them like naughty school children, not political martyrs. And in doing so, she exposed the strings of the puppets. When the judge wrote in her evening order that the proceedings had elements of political performance art, she wasn't being poetic. She was issuing a judicial finding that the court was being used as a prop. This is the most dangerous part of the game. When you treat a court of law like a campaign stop, you aren't just breaking the rules. You are breaking the belief system that holds the country together. You are telling your followers that the law is a joke, that judges are partisan hacks, and that the only thing that matters is power. But playing chicken with the federal government has consequences. Real consequences. Not Twitter jail consequences, but federal prison consequences. And as the sun set over Manhattan on Friday, the realization started to sink in. The performance is over, the reviews are in, and now the bill is coming due. And let me tell you, the price tag for this little piece of theater is going to be astronomical. So the play is over, the actors have left the stage, but in the cold light of Saturday morning, the reality is setting in, and it is ugly. Judge Caldwell isn't just angry, she is methodical. After the stunt pulled on Friday, she dropped a phrase into the record that sent shivers down the spine of the entire legal profession: shadow counsel. It sounds like something from a spy novel, doesn't it? But in federal court, shadow counsel is the ultimate vote of no confidence. It means the judge doesn't trust your lawyers to actually be lawyers anymore. It means she is considering appointing a backup team understudies who sit in the courtroom, silently watching, ready to jump in and take over the defense the second the main team tries to pull another stunt. Imagine the humiliation. You are a partner at a premier law firm, and the judge forces you to work with a court-appointed babysitter because she thinks you might try to run away again. And speaking of law firms, let's talk about the money. Not the campaign donations, but the business of law. Sterling's firm has billed over $12 million for this case. That's a lot of billable hours. But late Friday night, reports started surfacing that the firm's malpractice insurance carrier is entering emergency crisis talks. Why? Because insurance companies hate political performance art. They insure against mistakes. They do not insure against intentional contempt of court. If this walkout leads to a mistrial, or if these lawyers get disbarred, the insurance carriers could deny coverage. That means the partners at the firm could be personally liable. We are talking about bankruptcy-level events for these lawyers. They gambled their careers on a political strategy, and now the House is coming to collect. But the biggest threat isn't to the lawyers, it's to the defendant. Sources say the prosecution is now discussing the nuclear option. They are considering filing a motion to revoke bail. The argument is brutal but logical. If a defendant's legal team cannot be controlled, and if they are actively trying to sabotage the proceedings to force a mistrial, then the defendant is a flight risk and a danger to the administration of justice. Will it happen? Probably not. Putting a former president in a holding cell during trial is a line almost no judge wants to cross. But the fact that it is even being discussed shows you how far off the rails we have gone. And this brings us to the final terrifying point. What we witnessed today wasn't just a bad day in court. It was a stress test for American democracy, and the red lights are flashing. If this strategy works, if you can simply order your lawyers to walk out when you're losing, if you can turn a criminal trial into a reality TV show, if you can break the rules and then fundraise off the punishment, then the legal system is dead. It ceases to be a system of justice and becomes just another weapon in the arsenal of the powerful. It means that if you have enough money and enough followers, the rules simply do not apply to you. Judge Caldwell held the line today. She locked the doors. She stood her ground. But she is just one judge in one courtroom. The question is, can the system hold? Witness 14 takes the stand on Tuesday. The secrets of the financial blackout are about to be read into the public record. The show is over and the truth is coming. The only question left is, are we ready to hear it? If you want to be in the room when that testimony drops, if you want to know what happens when the irresistible force of political power meets the immovable object of the law, you know what to do. Subscribe. Turn on notifications, because come Tuesday, history isn't just being written, it's being cross-examined.